Greetings and welcome to Summary Judgment, Part 8, Governing Rules, Principles, and Considerations. And this is condensed from American Jurisprudence, the 2008 supplement. Before we get started, welcome to everyone here. And remember that this broadcast is strictly for the entertainment and educational purposes of the YouTube channel, not to be used, misconstrued, or abused for anything personal, private, business, tax, legal, lawful, financial, or otherwise. So don't take this as advice, and certainly don't do this at home. That said, let's get started. So we left off last time on the next chapter here where we get to determination. And that includes the governing rules, principles, and considerations. And starting with what constitutes a genuine issue of material fact. We keep hearing this over and over again. Genuine issue of material fact. So let's start with section 45 generally. And just let you know that this is all going to be about section 45 because, as I said, the summary judgment volume here, the cases that it references are based upon very short, brief overviews that don't include trial and jury and fact-finding and all those deliberations. Therefore, we can actually get through a high volume of fully analyzing these cases and in their impact on the judicial precedents very rapidly, get good practice, and so to speak, sharpen the saw as far as going through and analyzing cases. So let's get started here with determining what constitutes a genuine issue of material fact, because that's crucial in summary judgment proceedings, as it determines whether a case must proceed to trial. So, a material or genuine issue of fact that will preclude the granting of summary judgment for the plaintiff is raised if the facts alleged by the defendant, if proved, are such to constitute a legal defense. So, what we're saying here is that a material or genuine issue of fact that will preclude the granting of a summary judgment for a plaintiff. So this is something that's going to make impossible to shut the door before it can happen on the summary judgment, to preclude it. So a material or genuine issue of material fact that will do this is raised if the facts alleged by the defendant, if proved, that's what these material or genuine issues of facts that can preclude the summary judgment. Okay, it's raised if the facts, those facts alleged by the defendant, if proved, are such as to constitute a legal defense. Key term. Let's continue here. If the affidavits on the one side and on the other are directly opposed as to the facts shown, the case must go to trial. So, if they're opposing the same facts, then it must go to trial by affidavit, of course. All doubts as to the existence of a material and triable issue of fact should be resolved against a party moving for summary judgment. Always, in the I guess, don't want to say bias here, but it's always judged in favor of the non-moving party. So, any doubts, you give the non-moving party the benefit of the doubt. No issue for trial unless there is sufficient evidence favoring the non-moving party for a jury to return a verdict for that party. So, sufficient evidence favoring the non-moving party for a jury to return a verdict. So that's the bar right there. No issue for trial unless there's sufficient evidence favoring the non-moving party. Remember, that's the one that's always the non-moving party gets the benefit of the doubt. So that would be the lowest bar for a jury to return a verdict for that party. Summary judgment may be granted if the issues are those that are usually questions of fact, but are established as a matter of law by the admissible evidence. So, this is another key one here, is that it can be granted if the issues are usually questions of fact, but they're established as a matter of law by the admissible evidence. So, in a particular legal theory, it seems here, it's usually questions of fact that are included there, but because there's already admissible evidence, those have been answered. So then it's back to just a matter of law. All right, that said, that's pretty much the overview. We need to get to these cases here. And at the end, we're going to have a very special surprise, so make sure you all stay to the end. So the First Amendment retaliation, public employee speech. Issue of fact existed as to whether secretary engaged in speech touching on public concern when inquiring about the propriety of qualifications in town job posting, precluding summary judgment on First Amendment retaliation claim. All right, so we had an issue of fact whether the secretary actually engaged in a particular kind of speech. So that needs to be judged by a jury. And that's Aquavia versus Goggin, Connecticut. Then we have a First Amendment retaliation with the school employee. Not just a public employee here, but we have the school employee. There's a genuine issue of material fact as to whether athletic directors' protected speech about a hazing incident was causally connected to the abolition of his position. That's a kind way of saying getting canned. Abolition of his position, given lapse of only several weeks between speech and job loss, precluding summary judgment on First Amendment retaliation claim. So yeah, a few weeks, speech about a hazing incident was causally connected. I guess that is something that really can't be judged, it can't be granted a summary judgment for. And that's Chiaffi versus Averill Park Central School District and Second Circuit 2006. Then we have, this is a great one here, the Warsaw Convention definition of an accident. A genuine issue of material fact regarding degree of turbulence and whether the passenger's injury was an accident within the meaning of the Warsaw Convention, precluding summary judgment in action against the airline. Yeah, that's really pushing it. The degree of turbulence was more than an accident. And that's Lufthansa. Geez, Magan versus Lufthansa German Airlines. Second Circuit 2003. I've actually curated these cases here from the section because there was a lot of cases and there's some redundancy in there, and I want to just stick to the ones that really will get the whole spirit of this summary judgment through, because it is a rather new addition to our judicial system of American jurisprudence, so to speak, being just from the late 1800s really is where the first time used, I believe. All right, so here we go. Section 45 continued for this whole presentation. There's a jury role in summary judgment. So if it's supposed to be, if it doesn't go to the jury, there's summary judgment. Now we see a jury role in it. Let's see. Credibility assessments. Choices between conflicting versions of events. And weighing evidence are matters for the jury, not for the court, on a motion for summary judgment. If any evidence exists from which a reasonable inference could be drawn in favor of the opposing party, summary judgment is improper. So there it is. If a reasonable inference could be drawn in favor of the opposing party, summary judgment is improper because there's a jury role. There's credibility assessments. So those need to be decided by a jury. Choices between conflicting versions of events and weighing evidence. All right. That's from the Curry versus City of Syracuse, and that's Second Circuit 2003. Now we have the LHWCA turnover duty. So this is Longshore something Workers' Compensation Act. All right, so we have a fact issue of whether a ship owner breached its turnover duty. So a turnover duty under the longshore is when they turn over the duty to the dock loaders or whoever else is handling the boat when they come into a dock, then it's they do a turnover. And when they do a turnover, they have a duty to make sure everything's safe or to disclose if there's any hazards before turning it over to someone else, the vessel. All right, so, or the cargo, whatever it is. Uh, that's just my interpretation. So it's a different turnover than in other things. This is turnover as it applies to the Longshore Act. Fact issue of whether shipowner breached its turnover duty under the LHWCA to longshoreman who fell through hole in ship deck due to rotten wood by failing to exercise reasonable care to warn stevedore about the defect. It precluded the summary judgment for the shipowner. So the shipowner couldn't get summary judgment because there was a reasonable, let's see here. Yeah, so the shipowner can't get it, so there's a fact issue whether he breaches duty. And the stevedore is the one loading the cargo or unloading the cargo. I think that comes from the Spanish stevedore. But that's, I digress. All right, that's from Lincoln versus Rexton Management in 4th Circuit, 2003. Now on to the qualified immunity. Deadly force. Genuine issue of material fact as to whether officer used deadly force when ramming his vehicle into fleeing motorist vehicle, causing motorist to lose control and crash, and whether the motorist driving posed substantial threat of imminent physical harm to others. Precluded summary judgment on qualified immunity grounds. Wow. So it looks like there was genuine issues whether the officer used deadly force when ramming his vehicle into a fleeing motorist vehicle. Jeez. Causing a motorist to lose control and crash, and whether the motorist driving posed substantial threat of imminent harm, physical harm to others. Oh, okay, so yeah, it's excessive force. Deadly force, excuse me. Yeah. Precludes summary judgment. Harris versus Coweta County, Georgia. 11th Circuit, 2005. All right, hope you all are still there. And if you have any questions or comments on any of these, please definitely pipe up. And I believe I have the talking chat on here. And if you type in the chat, it should read it.
The crime says, hit the like.
Indeed. There we go. All right, let's proceed. So now we're on to the qualified immunity for excessive force. That was deadly force. Now we're on to excessive force. Genuine issue of material fact as to whether arrestee was armed and not yet subdued or disarmed and handcuffed when the police sergeant held him down and ordered another officer to beat him and shoot him in the head. Jeez. What? Precluded summary judgment on qualified immunity grounds on arrestee's Section 1983 claim alleging use of excessive force. Phew. So, what does it matter if he's armed and not yet subdued or disarmed and handcuffed? Jeez. Well, I guess, yeah, there's no qualified immunity if he's disarmed and handcuffed when the sergeant held him down and ordered another officer to beat him and shoot him in the head. Jeez, and that's Arrington versus U.S. D.C. Okay, Circuit 2006. All right. Let's continue on here with something hopefully a little less intense. The insurance coverage exclusion defense. This is a little bit more hitting back to a little home action here. Genuine issue of material fact as to whether driver used automobile owned by his aunt and uncle with their consent on the day of the accident precluded summary judgment for automobile insurer on indemnification claim brought by accident victim and his father, to which insurer asserted defense was that driver was excluded from coverage due to lack of reasonable belief that he was entitled to use the automobile. He stole his aunt and uncle's car is what they're claiming here. Took it for a joyride and crashed it. Now they're saying, he had no reasonable belief that he was entitled to use that automobile. But that was not a matter for them to do through summary judgment, so it was denied, it looks like here, and that's it. And that was Atheridge versus Aetna Casualty and Surety Company, DC 2003. Now we're on to the Civil Asset Forfeiture Reform Act. Genuine issue of material fact existed as to whether claimant was innocent purchaser of real property, precluding summary judgment under Civil Asset Forfeiture Reform Act, the CAFRA, even though non-judicial foreclosure proceedings were instituted against the property, and the property was sold at public auction. The innocent purchaser of real property precludes but it still precludes summary judgment. So looks like it has to go to trial here. U.S. versus one residential property located at 8110 East Mojave Road, Paradise Valley, Arizona. that's so. Civil forfeiture is very strange because it's there's a crime or something against property, not against a person. One residential property instead of one person, one man, or one woman, or anything. Not even a corporation. It's one residential property located at, and it gives an address. Interesting. These civil assature cases are just crazy. All right, let's move along. Now we're on to the cross motions for summary judgment. In ruling on cross motions for summary judgment, the court shall grant summary judgment only if one of the moving parties is entitled to judgment as a matter of law upon material facts that are not genuinely disputed. So you have some facts, no one's disputing the facts, it was daytime, things like that, and is based on that, then it's the ruling on the cross, the court shall grant summary only if one of the moving parties is entitled. What if both of them are? Well, then there's a conflict somewhere, it needs to go to trial. But only if one of the moving parties is entitled to judgment as a matter of law upon the material facts that are not genuinely disputed. That's American Cargo Transport versus Natsios, and that's DC 2006. Now we're on to a good one here, the Freedom of Information Act. Some FOIA action here with search adequacy. Wow. Genuine issue material fact existed as to whether it was reasonable and adequate for the United States Department of Agriculture, the USDA, not to search for the offices of two individuals for responsive records to the farmer's request, pursuant to the Freedom of Information, FOIA, precluding summary judgment for the USDA. So the USDA was precluded from trying to get out of it with a summary judgment. Good. Stick up for FOIA here. That's Galaxy versus USDA, DC 2003. Now we have some art. Seized paintings. Joint ownership. So art thieves. Genuine issue material fact as to whether individual who originally owned two oil paintings, an entity formed to facilitate transfer and sale of the paintings, were joint owners of the paintings at the time they were seized by the government in criminal proceeding, precluded summary judgment in action seeking paintings returned. Yeah, I don't think they're getting their paintings back. All right, that's DeSaro versus U.S. Oh, that's Southern District of Florida, 2004. All right. Come on, let's go. There we go. All right. Now we're on to the UCC, the Uniform Commercial Code, and contract compliance. Remember, the contracts are a big issue. Contract issues are a big part of summary judgment. So let's see what we got here. The genuine issues of material fact as to whether the parties, hang on a second here, as to whether the parties intended that trading cards made with the same materials would be direct food contact compatible within the meaning of the contract, and whether the odor on the cards was worse than what had been anticipated before. Accepted before. All right, so they got some materials, trading cards. They're supposed to be direct food contact compatible. Hopefully, they aren't being touching food, but they're just compatible within the meaning of the contract. And whether the odor on the cards was worse than what had been accepted before. Oh boy. So you're saying the odor. How do you quantify that odor for the court? Well, that's the thing. It precluded summary judgment on whether the trading cards bearing Britney Spears' image conform to contract specifications under UCC. Oh, man. Britney Spears. All right. She made it to American jurisprudence. She's that's about as good as you can get. Grace label
Document 4426 says, does not pass the smell test.
That is a bizarre case there, I must say. Very bizarre. But you see, Britney Spears made it into American jurisprudence, so, salute to her. All right, the Kansas Whistleblower Act. Oh, that, by the way, that was Grace Label versus Cliff and Southern District of Iowa, 2005. Now we have the Kansas Whistleblower Act. Genuine issues of material fact as to whether the truck driving school instructor, here's a whistleblower, he blows a horn and a whistle, huh? The truck driving school instructor whose hours were reduced and who was laid off after he reported safety and maintenance violations, sufficiently reported infractions to upper management, and whether the instructor reasonably believed defendants had committed those violations, precluded summary judgment on instructor's claim under Kansas Whistleblower Act law. So here's the questions. Genuine issues. After he reported the safety violations, whether he sufficiently reported the infractions to upper management, whether he just complained about it or reported them but didn't report them sufficiently, and as to whether the instructor reasonably believed that these things committed those violations. So I could see it could be seen as retaliatory. And whistleblower acts meant to protect things where they're trying to be silenced. However, in this case here, they found there were genuine issues of material fact that had to be resolved first. So he couldn't get by with a summary judgment. All right, that's Rowland versus Franklin Career Services, Kansas 2003. Now we're on to the sham fact issue. Summary judgment. Factors relevant to the existence of a sham fact issue on a motion for summary judgment include whether the affiant was cross-examined during his earlier testimony, whether the affiant had access to the pertinent evidence at the time of his earlier testimony, and whether the earlier testimony reflects confusion, which the affidavit attempts to explain. So putting in some new information here, explaining previous confusion. So all these things in here would be to prevent it from looking like a sham. So the factors relevant to the existence of a sham fact issue on motion for summary judgment. So trying to make up an issue of fact that isn't there. But here's how we check. Was the affiant cross-examined? Because if they were cross-examined, he can sniff out the sham in his earlier testimony, whether the affiant had access to the pertinent evidence at the time of his earlier testimony, so whether he was well informed, he wasn't ignorant of anything, and whether the earlier testimony reflects confusion, which then you have some affidavit with new evidence attempting to explain that. All right, that's Hill versus McHenry, Kansas 2002. So that's how the factors that are relevant to the existence of a sham fact issue, trying to make up facts to try to on motion for summary judgment. All right, now we're on to the New York Deceptive Practices Statute. Material issues of genuine fact existed as to whether used car dealer, let's see, this is Diaz versus Paragon Motors of Woodside, Oh yeah, Eastern District of New York, 2006. So here we got New York car salesman here. Material issues of genuine fact existed as to whether used car dealer, which violated Truth in Lending Act and New York vehicle and traffic law provision requiring seller to provide disclosure of vehicle's prior use, engaged in a materially misleading act, and whether dealers' challenged practices were consumer oriented or buyers suffered injury as a result of the deceptive act. Precluding summary judgment in favor of dealers precluding summary judgment in favor of dealer on buyer's claim under New York deceptive or unfair practices statute. So it looks like it precludes the judgment in favor. Wow, precluding summary judgment. Okay, in favor of the deal. Okay, so it's in favor of dealer. You get the way they write these things. It's very condensed. Even though these cases are very condensed, as you can see here, this is it of the cases we're reading here because they're summary judgment cases. They contain no jury or deliberations or any of the other trial elements that would make it a little bit more voluminous. And we can really shed through a few of these if I stop talking and we move on to the excessive force under Section 1983. Genuine issues of material fact as to whether public school director of pupil services striking of disabled student's mother while she was reviewing her son's records amounted to an abuse of power that shocked the conscience, precluded summary judgment for director on mother's excessive force claims under Section 1983 and New York law. Whoa, that's a heavy one here. That's Aram versus Miller, and of course, Eastern District, New York, 2003. So one more time here. She's doing a Section 1983 because it's a public school director. So the genuine issues of material fact as to whether this public school director of pupil services striking of a disabled student's mother. So this guy here, or woman, whatever it is, the school director, public school director of pupil services, strikes this disabled student's mother while she was reviewing her son's records. And it amounted to an abuse of power that shocked the conscience. But what do they mean by shocked the conscience? How do you shock a conscience? It seems like, to me, a legal terminology. If it's a legal terminology, it has a special meaning, especially in this context, which means we really need to do what we got to do, and that means go to Black's Law. All right. Bear with me here, and let's see if we can get there to shock the conscience. Let's see here. Come on. All right. Okay, so we're here by our ships. Oh boy. Wait, here we go. Look at this. Shock the conscience. In Black's Law, indeed. Let's read this. To cause intense ethical or humanitarian discomfort. This phrase is used as an equitable standard for gauging whether 1. State action amounts to a violation of a person's substantive due process rights. 2. A jury's award is excessive. 3. A fine, jail term, or other penalty is disproportionate to the crime. Or 4. A contract is unconscionable. Wow. So this is the statement, used as an equitable standard for gauging whether a state action amounts to a violation of a person's substantive due process rights. Well, it seemed like it did in this case here, right? A jury's award is excessive. That would shock the conscience, huh? Geez, a fine, oh wow, a jail term or other penalty is disproportionate to the crime. Wow. Or 4, a contract is unconscionable. C, conscience of the court. Wow. That's an interesting one there. Uh, if you guys want, we could go and look up conscience of the court. Otherwise, we'll just continue here. Someone's going to pipe up, or else we're just going to go ahead and continue. In the meantime, I'm just scrolling up here until I hear someone say something. But this thing moves really slow. Well, pretty close here. All right, what do we got here? It looks like it's stalled. So is a conscience of the court. Right there, let's just look at it. I think we're near it. We can get through contracts here. Let's just do a little jump. Wow, a lot of contracts. All right. Let's see, consensual. Let's see. Oh, condicio. Okay, yeah, it's over here. CONSC. We're selling contracts. That's what the problem is. All right, it should be there very soon. Oof. I hope you all are still there. For those of you are, we're just about conscience. There it is. Conscience of the court, 17th century. All right, Bill Thomas, thanks for sticking around. Conscience of the court, 17th century. The court's equitable power to decide issues based on notions of fairness and justice. See equity. 2. A standard applied by the court in deciding whether a party or a jury has acted within acceptable limits. Wow. Thus, in some cases, a jury's award of damages is upset because it is said to shock the conscience of the court. See, shock the conscience. Okay, so we took care of all that. And I think we can move on in confidence now and not worry about shocking the conscience any longer. But we could see where it did from the first definition we saw of here. It definitely applies to this mother's act, what they did to her here. This is something that could definitely shock the conscience, that abuse of power, state power. And this is under Section 1983, so that's what would apply. But it is genuine issues of material fact, and that's for the jury. But oh boy, try explaining why you're striking the disabled student's mother while she's reviewing her son's records to a jury. All right. Negligence action, proximate cause, so the nearest cause, right? Genuine issues of material fact regarding whether pedestrians' failure to see beam.
Bill Thomas 4426 says can't tell if the student or mother is disabled.
No, it's a mother of disabled student. It's the disabled student's mother, it says. So the mother's not disabled, the student was. And it's a director of pupils services. And the mother was looking at reviewing her son's records, the disabled son, and they struck her. And it was a abuse of power that shocked the conscience, is what. But it precluded summary judgment because there are genuine issues of material fact as whether it actually did that. You know, so, but again, fine, let the jury decide. You know, I mean, explain why that's happening there to a jury, unless they really did, that's not what happened. But I have a feeling, being that we're reading it here, this went to the appeals, and that's why, it didn't. They tried to push that summary judgment, didn't they? All right, let's move along here. So we're the genuine issues of material fact here regarding whether the pedestrian's failure to see a beam. So there must be some beam laying on the ground here. It's of his own negligent inattention or city's negligent failure to put a reflector on the barrier was proximate cause of injury sustained by pedestrian when he tripped and fell on beam. So which one it was? It was his own inattention, or was it a failure to put the reflector? Well, that precludes summary judgment for city and pedestrian's negligence action under New York law. So the city summary judgment for the city wasn't going to happen. That's Rill versus City of New York, 2004. Let's move along. And we're on to the negligent suits, the drowning incident. Genuine issues of material fact whether a resort's owner and operators acted reasonably to prevent a patron's drowning in a pool, and as to the cause of the patron's death, precluded summary judgment for the resort's owners and operators in a negligence suit brought by the patron's widow. So this is saying that there were genuine issues whether the resort owners acted reasonably to prevent the drowning, and as to the cause of the patron's death. So did he die from the drowning, or did he, die and then drown? So that precluded the summary judgment for the resort's owners and operators in a negligence suit brought by the patron's widow. And that's Towns, estate of Towns versus Cove Haven. I don't know if I'd want to stay in Cove Haven. It sounds pretty risky. And 2003, New York. Sales agreement, warranty of non-existence. And by the way, before I keep going too far, if you have arrived soon and you're enjoying it, please hit the like, because we got to get more people in here before we get to the special surprise at the very end. And that's coming up very soon. So let's continue. So we have a sales agreement warranty of non-existence. Material issue of fact as to whether seller of magazine business knew or should have known that the photographer working for the magazine would claim that he owned rights to allegedly key group of pictures. Precluded summary judgment that the seller breached provision of sales agreement warranting non-existence of claims relating to proposed sale. Wow. This is shifty here. This is Primedia Enthusiast Publications versus Ashton and International Media. Of course, New York, 2003. So here's something I find odd here. The material issues of fact as to whether the seller of magazine business knew or should have known that photographer working for the magazine would claim that he owned rights to allegedly key group of pictures. If the photographer, if that was his work, he owns it. If he typically what the photographer, especially in New York, would do, they would give unlimited business license to the magazine business. They wouldn't be the magazine business's property or the rights to it. He would own the rights to his creative works. He would grant them, say, unlimited license to use for whatever purposes, but he would retain the rights so that they can't resell them, so to speak. And here is the magazine business is selling the business, and he's should have known that a photographer working for them would claim that he owned rights. And so it looks like the company that bought it was upset that this guy owned the rights to the photos, and he probably wanted to relicense them to the new owner. And the fact is here is that to me, in the way my opinion on this really seems like he should have known. The seller of the magazine business should have known, because that's common knowledge. That's something even I know. and I don't have a magazine business. This is kind of what you would call common knowledge in the industry. So this seems pretty strange here. But this is, again, for summary judgment. How this panned out, I don't know. But that, again, you can see here where even things that you think are common knowledge aren't enough to establish a summary judgment, because you could still find the material issues of fact, because you still need to know. Has he been, deposed? And again, if you have conflicting statements from different people, then the jury needs to decide on that. All right, let's move along. RICO claims, summary judgment. District Court's sua sponte grant of summary judgment. This is on the court's own initiative, their own spontaneity here, meaning that no one had to make the motion, that the court could do it themselves. So they made a grant of summary judgment, sua sponte, dismissing Racketeering, Influence, and Organizations Act. It sure be ashamed if you didn't grant us that summary judgment, but your attorney didn't do it. Do it sua sponte, Judge. RICO claims by a company engaged in wholesale closeout business and its founders against employee of hosiery manufacturer was proper. Court already had all evidentiary materials that plaintiffs might have submitted, and evidence showed that no genuine issue of material fact existed, which would preclude summary judgment for employee. Wow. That's an interesting one there. That's USA Certified Merchants LLC versus Cobell. And of course, New York, 2003. That's an interesting one there with the RICO one getting dismissed sua sponte. What would influence that? All right. Now we have a breach of implied warranty. Genuine issue material fact as to whether motorhome was fit for purpose intended. Precluded precluded summary judgment on buyer's claims against seller for breach of implied warranty on merchantability and revocation of acceptance. Wow. That's buyer's remorse if I ever heard it. Cannon versus Newmar Court in New York, 2003. Then we have the ancillary matter, summary judgment. So supporting matters, things that are necessary for something to function, but not the main matter here. So the alleged factual dispute between parties as to some ancillary matter will not defeat otherwise properly supported motion for summary judgment. So you had to bring material facts, right? Not ancillary matters. That's Cloak versus West Claremont Local School District Board of Education, Southern District of Ohio, 2006. Now we have the material facts definition. Here's a great, this is our whole case here from barrier versus simplicity. And what a proper name for this. Pennsylvania, 2005, Simplicity Corp. Only facts that may affect the outcome of a case are material for summary judgment purposes. So we talk genuine issues of material facts. Well, only facts that may affect the outcome of a case are material for summary judgment purposes. So there's your definition right there, very succinct. Every word tells. Let's move along. And that's a good case right there. Barringer versus Simplicity. Even the name Simplicity speaks to the length of the citation here. And 2005, Pennsylvania. All right, so we got the Federal Tort Claims Act, FTCA, in action against the United States pursuant to Federal Tort Claims Act by pedestrian who tripped on sidewalk, another sidewalk tripper, owned and maintained by government. Genuine issues of material fact regarding degree of unevenness of a sidewalk, degree of danger created by uneven edge, and whether pedestrian was comparatively negligent. Was he inattentive, drunk? Precluded summary judgment, of course. And that's Quinones Sepulveda versus U.S. And that was in Puerto Rico, 2003, and their uneven sidewalks. so to speak, here. Of course, that's allegedly because we don't know the degree of unevenness. All right, now we're on to habeas corpus proceeding. Genuine issue of material fact existed as to whether correctional facilities insufficient legal resources was cause for petitioner's procedural default of federal claims in state court, precluding summary judgment for state in petitioner's habeas corpus proceeding. Oh, that's good. So there are genuine issues of material fact as whether there is insufficient legal resources, and that's cause for a procedural defect of federal claims, and that precludes a summary judgment. That's nice. Tyler versus McGautry, and that's Wisconsin 2003. Oh, now we have the Religious Land Use Act. And please, everyone, pipe up in the chat. The more we interact in the chat, the more we can attract other viewers in here to participate and engage. And like I said, we have a special surprise coming up and a few more slides. So stay tuned and let's continue. Religious Land Use Act. Genuine issues of material fact existed as to whether operating a daycare with a religious component constituted religious exercise under Religious Land Use and Institutionalized Persons Act, the RLUIPA. You might as well just say it. Whether cities' land use regulations substantially burdened the church's exercise of religion, and as to whether the operation of the daycare was a sincere exercise of the church's religion. Yes, it's in the Bible. It said something about running daycare services was part of exercising your religion. And that's Grace United Methodist Church versus the City of Cheyenne, Wyoming, 2002. All right. We're on to the summary judgment standard now. We got our definition. And that's our standard from Maddox versus City of Fort Smith in 2001. So it's a little bit older. Summary judgment.
4426 says, "Let the little ones come to me."
Yeah, there you go. I guess they could, you know what? They could get real creative with that. I'm sure you could pull a lot of verses and cite it, and have it all judicially noticed, etc. But I digress. Let's continue here. The summary judgment standard. Summary judgment is appropriate when the pleadings, depositions, answers to interrogatories, responses to requests for admission, and affidavits show that there is no genuine question of material fact to be litigated, and the moving party is entitled to judgment as a matter of law. So that's our standard. It's appropriate when the pleadings, depositions, answers to interrogatories, responses to requests for admission, and affidavits. So there's your laundry list. Pleadings 1, depositions 2, answers to interrogatories 3, responses to requests for admissions 4, and 5, the affidavits, usually the most important. Show that there is no genuine question of material fact to be litigated, and the moving party is entitled to judgment. Then you need that legal theory here as a matter of law, so that facts you've gotten from all these things show that there's no question of material fact. All well established, not disputed, and they all play into the entitlement as a matter of law for the summary judgment. All right, now we have the directed verdict test. The test is, so we all know what a directed verdict is, right? I'm sure we've heard it a lot, but we probably need to get back to blacks to get, and I think that would be under verdict, because, let's see here. All right, we're here in the V's. There's verdict. Verdict is from the 15th century. A jury's finding or decision on the factual issues of a case. Loosely, in a non-jury trial, loosely. A judge's resolution.
4426 says, "Court decides in a directed verdict if I remember."
Indeed. So let's get the exact one here. Defective verdict. Here we go. Directed verdict. It's only from 1912. As you see here, summary judgment is actually early 20th century. A ruling by a trial judge taking a case from the jury because the evidence will permit only one reasonable verdict. So once again, the directed verdict from 1912, again, this is getting the 20th century, so this is rather recent. It's a ruling by a trial judge taking a case from the jury because the evidence will permit only one reasonable verdict. So because the evidence will only permit one reasonable verdict, then the trial judge can take the case from a jury. So let's see how now that ties in with the summary judgment. Okay. So the
Bill
directed
4426 says, directed overrides a jury. Summary judgment precludes a jury. Correct?
Yes. Summary, yeah, but there would be exactly. If there's a need for a jury, then there can be no summary judgment. And a directed verdict is something where the facts, there's no facts to be questioned of fact. Hang on, it looks like the stream was just dying for a second there. All right, we're back. With a directed verdict, there's no issue of fact for a jury to decide. So I guess it's not really overriding, it's taking it away so the jury doesn't even get to consider. But that said, let's see where that ties in here with our summary judgment, because there's a direct verdict test. The test is whether the party moving for summary judgment would be entitled to a directed verdict on the same facts. Wow. Okay, so here we go. So if it was going to be a directed verdict, you would still be precluded by the summary judgment in this case if it passes the directed verdict test, because this test is whether the party moving for summary judgment would be entitled, meaning that there's no facts to be, no question of facts for the jury, and that a judge would be able to take the case to decide it from the jury because it could be decided strictly on the law, matters of law. So the test is whether the party moving for summary judgment would be entitled to a directed verdict on the same facts. And that's from Provencher versus Town of Enfield, Connecticut, 2007. Nice test here. So if it would be entitled to a directed verdict because of the evidence, then the party moving for summary judgment passes that directed verdict test. Another reason for a judge to grant a summary judgment. You pass a directed verdict test with the evidence. All right, summary judgment criteria. Summary judgment is appropriate if the pleadings, depositions, answers to interrogatories, and admissions on file, together with the affidavits, if any, show that there is no genuine issue as to any material fact, and that the moving party is entitled to judgment as a matter of law. That's Kuhn versus City and County of Honolulu, 2002. Okay, some more cross motions for summary judgment. If the case is to be tried by the court without a jury, where cross motions for summary judgment are filed based upon the same evidentiary facts and upon the same theories and issues, the parties of this effectively have stipulated that no genuine issues of material fact exist. So if they're both basing their theories on the same evidentiary facts and theories and issues, right, then there's no dispute of the facts because they're basing both their theories on the same facts. That's Zollinger versus Carroll, Idaho, 2002. Now we have where summary judgment is appropriate. Summary judgment is appropriate if there is no genuine issue as to any material fact and the moving party is entitled to a judgment as a matter of law. That's Weinstein versus KLT Telecom, Missouri, 2007. Then we have the evidentiary hearing standard. Ooh, this is a good one here. In light of a trial court's failure to conduct an evidentiary hearing on cross motions for summary judgment. Wow. Genuine issues of material fact existed as to whether former county attorney was entitled to a specified salary and to benefits, whether he performed all the conditions and requirements of his employment, and whether county ceased paying him his salary and benefits during the period of time he was erroneously removed from office, precluding summary judgment for county on attorney's claim for salary and benefits. Jeez. So it's in light of a trial court's failure to conduct the evidentiary hearing on cross motions for summary judgment. Wow, genuine issues of material fact existed as to whether the county attorney. So yeah, all right. Hogan versus Garden County, Nebraska, 2002. Anyone want to comment on that? That just seems like someone trying to recover some extra funds there for their pseudo services, so to speak. All right, we're on to the summary judgment standard. Again, the summary judgment standard requires a trial court to grant judgment for the moving party when looking at the evidence as a whole. So the evidence as a whole, all of it, there's no genuine issue of material fact remains to be litigated. 2, the moving party is entitled to judgment as a matter of law, and it appears from the evidence construed most strongly in favor of the non-moving party that reasonable minds could only conclude in favor of the moving party. So we're talking about preponderance of evidence and beyond reasonable doubt, all these different standards. This is construed most strongly in favor of the non-moving party that reasonable minds could only conclude in favor of the moving party. That's your standard. High standard. And that comes from Sinnott versus Aquachem, Ohio, 2007. Now we're on to the issue of material fact, preservation. The investor did not preserve for review. In action against, and review, I think this is for the appeal, in action against attorney and bank to recover money investor lost in Ponzi scheme. Issue of whether the affidavit from investor's expert created an issue of material fact as to whether bank, which was used as a conduit through which investor contributed to the scheme, owed investor any fiduciary duties or duties to exercise due care, where trial court did not indicate whether it would consider affidavit and did not address affidavit in written order granting bank summary judgment. Okay, so you get to preserve issues of material fact, preservation. That's Calburn versus Leventis in 2005. So Connecticut. Now we're on no evidence summary judgment. As we say here, we have unless the respondent produces summary judgment evidence raising a genuine issue of material fact, the court must grant the motion for no evidence summary judgment. Okay, unless the respondent produces summary judgment evidence raising a genuine issue of material fact for no evidence. Okay, there you go. That's Western Investments versus Urena, Texas, 2005. Let's keep moving. Almost there. For those of you that are still here, we've got a special treat coming up, so stick around. The traditional summary judgment standard. Now we're talking about we went to the no evidence summary judgment to a traditional summary judgment. To succeed in a motion for traditional summary judgment, a movement must establish that there is no genuine issue of material fact, so that the movement is entitled to judgment as a matter of law. Now we have combining them. So we went to the no evidence, we get to the traditional. Now we're getting to the combining summary judgment claims. Summary judgment rule does not prohibit a party from combining in a single motion. So this could be a practice tip. Summary judgment rule does not prohibit a party from combining in a single motion a request for summary judgment that contains both traditional and no evidence summary judgment claims. So that sounds pretty good there. That's Binner versus Jacobo, Texas 2004. And furthermore, with the headings for summary judgment motions, while using headings to clearly delineate the basis for a summary judgment motion brought under traditional summary judgment claims from basis for summary judgment motion brought under no evidence summary judgment claim. Okay, wait, let's read this again. While using headings to clearly delineate the basis for a summary judgment motion brought under traditional summary judgment claims. All right, so we're going to delineate that one from the basis for summary judgment motion brought under no evidence summary judgment claim would be, it says here, okay, would be the better practice. So what this is so awkwardly written, but I guess it is right. It's just hard to read. So while using headings to clearly delineate the basis for summary judgment motion brought under traditional summary judgment claims from basis for summary judgment motion brought under no evidence summary judgment claim would be the better practice. Which one is that? I think the second is what they're trying to say here. Summary judgment rule does not require it. Rather, if a motion clearly sets forth its grounds and otherwise meets the summary judgment rule, it is sufficient. The basis for summary judgment. Okay, whatever. So there's for headings. It doesn't require. It's just better to use that heading, I guess, of no evidence. Wow, that's confusing. All right, let me get it on here. Texas 2004. If anyone else wants to clarify if they get that better. But here we get to the scintilla of evidence standard. When evidence offered to prove a vital fact in response to a motion for summary judgment is so weak as to do no more than create a mere surmise or suspicion of its existence, the evidence is no more than a scintilla and, in effect, is no evidence. So it can't be something that's a mere surmise or suspicion of its existence. That's a scintilla. You need more than a scintilla. That's from Ford Motor. All these are going to be from Ford Motor Company versus Ridgeway, Texas, 2004. Then there's the genuine issue material fact. For purposes of motion for summary judgment, a genuine issue material fact exists if more than a scintilla of evidence establishing the existence of the challenged element is produced. It's more than a scintilla. Okay? For purposes, a genuine issue material fact exists if more than a scintilla. That's all it takes. More than a scintilla. More than a mere surmise or suspicion of its existence. It doesn't have to be proven. It just has to be more than a scintilla. And then there's the direct and circumstantial evidence. Both direct and circumstantial evidence may be used to establish any material fact in response to motion for summary judgment. All right, let's move along. Now we're on to expert testimony and the material issue of fact. A purchaser's engineering expert's testimony that
Bill Simmons 4426 says how many scintilla in its mission.
To more than a scotch. All right. Indeed, this scintilla. Well, more than a mere surmise. More than just a thin wafer. It's only wafer thin. All right, here we go. Though expert testimony in the material issue of fact. We have the purchaser's engineering expert's testimony. It's an engineering expert's testimony that integrity of a foundation's tendon system was just questionable. Did not create material issue of fact as to damages that would preclude summary judgment on purchaser's fraud claims arising out of home sales, since expert also testified that there might be nothing wrong with the foundation. That's a good expert there, right? Delfino versus Holmes. That's Texas 2007. Oh, now we have the voluminous record and insufficient reference. This is a great one here. A general reference to a voluminous record that does not direct the trial court and parties to the evidence on which the movement relies is insufficient to create a genuine issue material fact for summary judgment purposes. That's a good one there. Voluminous record and insufficient reference. And who tried that one? Aguilar versus Morales in Texas 2005. Now let's see when summary judgment is proper. Summary judgment is proper if the pleadings, affidavit, and depositions establish that there is no genuine issue material fact and that the moving party is entitled to judgment as a matter of law. That's American Safety Casualty Insurance Company versus City of Olympia, 2007. Probably one of the shortest insurance cases we will cite. And where summary judgment is appropriate, summary judgment is appropriate when there is no genuine issue as to any material fact and the moving party is entitled to a judgment as a matter of law. And that's Erickson versus Ethan Allen, 2007, Washington. Now we have a factual dispute in the materiality requirement. So we're talking about the genuine issue of material fact. So what about this materiality? Oh, geez. The materiality requirement. Mere existence of some alleged factual dispute between parties will not defeat an otherwise properly supported motion for summary judgment, so long as there is no disputed fact that is material to the claim or defense made. So that materiality requirement for the factual dispute. So it's just the mere existence of some alleged factual dispute. It has to be material to the claim, as we saw before. It would affect the outcome. That's what makes it material. All right, now we're on to the genuine dispute. Summary judgment bar. If there is a genuine dispute as to one or more material facts, summary judgment should not be granted. And that's Wisconsin Mall Properties versus Junkers, Wisconsin 2006. Oh, by the way, the last case about the materiality requirement is Butler versus Advanced Drainage Systems, Wisconsin 2006. All right, now we're at the best part for those of you that stuck around, and we're going to see what we learned here and test your knowledge. So here's how this works. We're going to do a quick quiz. It's a fun quiz, and you participate by putting in the number of the question and the letter of the answer you choose. So for this one, if you're going to do question 1, you go 1. If I was picking D, it'd be 1D. All right, so let's read these questions and pick which answer you think is best to test your knowledge. So what standard of evidence is required to preclude summary judgment, to make summary judgment impossible, to shut the door, so to speak, on summary judgment before it can commence? A, what's the standard required to preclude it? A mere scintilla of evidence, A. B, more than a scintilla of evidence? C, only direct evidence? Or D, any evidence, regardless of quality? So this one here should be pretty easy. We just went over this one. And anyone who wants to put in some answers, go ahead and pipe up.
Bill Thimmett 4426 says 1A.
All right, you're saying that only a mere scintilla of evidence is required to preclude summary judgment. Is that your final answer? Well, let's move on. Question number 2. When is summary judgment appropriate according to the text? A, so when is it appropriate? We just read that one, didn't we? When evidence is merely colorable. B, when there's no genuine issue material fact. C, when affidavits on both sides are opposed. Or D, when there is any doubt about material facts. So this one should be pretty straightforward too. When is it appropriate for a summary judgment? So, of course, this is when would it be appropriate to even make a motion for summary judgment based on your legal theory? Would it be A, when evidence is merely colorable? B, when there is no genuine issue of material fact? C, when affidavits on both sides are opposed? Or D, when there's any doubt about material facts? All right, so question 2, your answer. And then we're
Bill
going to
limit 4426 says 2, capital B.
2B. All right, when there is no genuine issue of material fact. All right, let's move on to the next set of questions. And we're on to question 3. How should courts resolve doubts about genuine issues of material fact? So there's a doubt about the issue of material fact. How should they resolve that doubt? A, in favor of the moving party. B, against the party
Bill
moving.
limit 4426 says, I will change 1 to D.
Okay, you're going to change 1 to D. We got it. Noted. Noted in the chat. All right, so on question 3 is, how should courts resolve the doubts about genuine issues of material fact? Should they do it A, in favor of the moving party? B, against the party moving for summary judgment? C, based on the court's discretion? Or D, by weighing evidence from both sides? So this one here should be pretty easy too. Question 3, how should the courts resolve doubts about genuine issues of material facts? Who do we give the benefit of the doubt to? In favor of the moving party? Against the party moving for summary judgment?
Bill limit 4426 says 2B.
2B, yes.
Bill limit 4426 says 3B rather.
3B, right. Okay, gotcha. And on 2 is B anyways. So 2B, 3B. And now we're on to question 4. What factors are relevant to determining if a factual issue is a sham? Well, we talk about the sham factual issues. Whether the affiant was cross-examined. B, whether affidavit is based on new evidence. C, whether earlier testimony reflects confusion. Or D, all of the above. So which factors are relevant in determining if a factual issue is a sham? So whether the affiant was cross-examined. B, whether the affidavit is based on new evidence. C, whether earlier testimony reflects confusion. Or D, all of the above. Go ahead and pipe up your answer on that one. And I'm just going to, while you're thinking about that, I'm going to look over here at the
Bill limit 4426 says 4D.
4D. All right. And you said you were going to change question 1. Wait. Were you saying you're changing a different question here? 1 to D. Are you sure about that? We got 4D here. Here's question 1. We'll give you one more chance at question 1. What standard of evidence is required to preclude summary judgment? A mere scintilla of evidence. B, more.
Bill limit 4426 says not sure.
Good. So now we're on to the answers. Let's get this done. Question for 1, what standard of evidence is required to preclude summary judgment? The answer is B, more than a scintilla of evidence. As we read in section 45, states that a genuine issue exists if more than a scintilla of evidence is produced. A mere scintilla is insufficient to preclude summary judgment. But if it's more than a scintilla was the from the case. That's what I believe the case cited was more than a scintilla. But a mere scintilla was not enough to preclude. It was insufficient. All right, let's get on to question 2. When is summary judgment appropriate? According to the text. B, when there is no genuine issue of material fact. So there it is, 2B. The explanation here is that the summary judgment is appropriate when pleadings, depositions, and affidavits show no genuine issue of material fact and the moving party is entitled to judgment as a matter of law. All right, now we're on to question 3. How should courts resolve doubts about genuine issues of material fact? B. Against the party moving for summary judgment. Remember, the non-moving gets the benefit of the doubt. It states here in Section 45, it's all Section 45, that all doubts as to the existence of a genuine issue of material fact should be resolved against a party moving for summary judgment. And question 4. What factors are relevant to determining if a factual issue is a sham? And the answer was D, all of the above. All of those are relevant. I identified all 3 factors as relevant. Whether a affiant was cross-examined, whether the affidavit is based on new evidence, right, and whether the earlier testimony reflects confusion. So that affidavit could clarify any of that confusion. So this is ways, if it's a sham, you're going to say, well, were any of these things done? And if so, then it's probably not a sham. All right, well, with that said, I believe it takes us to the end of this presentation. This was part 8, and we really dug deep into the cases. And as you can see, for good reason, because we got through a lot of them on this one here. And this is just one section. It's a kind of a rarity to have this many in one section. But again, the nature of summary judgment cases, we can really cram in a lot. So I hope you all enjoyed doing this and getting to sharpen the saw a little bit on analyzing these cases and seeing where the rubber meets the road and all the different pitfalls and other unexpected consequences that might appear when you get into the details of these cases. And I hope some of them are interesting enough to make you think a little bit too about how these things really make a connection into our day-to-day lives and really do have impact on the way policies and laws and other codes and stuff are constructed and stuff to avoid some of these situations we're reading about. With that said, salute to you all for being here, and I hope to see you all on the next one. And thanks for participating into the test, Bill Thomas, and everybody else that did it on their own paper and pen in the background. And we'll see you all on the next one. Peace out.
Bill from 4426 says take care all.